Oops, not running.
Well, is
And-
it true that the boundaries are kind of unknown in those areas?
Apparently, I've never worked right down there. There are places where it's confusing. There's some places where it's very simple, like on the western boundary of 204, it matches the DuPage County line. So 204 and 131 just go straight up and down the DuPage-Kane County line. That's relatively easy. There are other places where you'll find school district boundaries, and they're very sawtooth. They're like up, down, all around the word. I've looked at a district map of Waubonsie's district, and there are some really odd-looking little, spits of area that, in fact, if you go down to the southeast, there's some areas that are much closer to Joliet that are in Waubonsie's district. And that's just the nature of how the district was formed originally, and it's stayed that way, and it doesn't make any sense the way the suburbs have grown anymore, but it apparently made sense 45 years ago to somebody somewhere. And the same thing is going out west. You get the same kind of thing where you would think, why is that person not in Kishwaukee's district? Why are they in Waubonsie's district? And up to the north, I was looking at something for somebody last year. They specifically asked if a particular location or area was inside our district or not, and I had to look at Waubonsie's district map, blow it up to the greatest degree I could, and it was so much all over the place, I still couldn't answer their question without looking at the tax bill.
My day job is a high school counselor. I work in Naperville, and this is the #1 reason why people move. It is school districts, and we changed boundaries last year. So I'm in 203, so for example, some students were originally part of one high school, they got shifted to another. That's not something that's publicized unless you call, you know what I'm saying? So
Yeah.
I think it's really tricky. And
Now that's,
I mean,
but that's inside 203, they switched high school boundaries from
correct.
central and
But
north.
if you move to go to one of the high schools within 203,
Yeah.
and we changed our boundaries, you're no longer going to where you thought you were. And I don't know what the parameters are, but I know rules are much stricter for, I don't know how they got away with it for 3 years. That's my comment.
Yeah,
what I'm
well,
saying.
and here we're crossing district lines. It's like the difference between 203 and 204, only it's
Right.
204 and 365 or whatever. So, yeah, I don't know how that worked either, except obviously somebody was asleep at the switch administratively with the district somehow. Today, I think with the way funding is, districts are looking at that a lot more closely, because if you go, in some cases you can go there, but you have to pay the full cost, make up for whatever the taxes would be that you would have paid if you lived in that district or whatever.
Well, I went to 204, and they had switched the boundaries. It used to be all as 60502. Went to 204, and then they switched it, and they went to 131. And a lot of kids who lived in, that Kane County side of 02,
Yeah,
they still ended up going for like at least a whole year.
to finish up.
And they didn't know, and the school would, try and weed them out and send them somewhere else or whatever, but
Interesting.
parents were like, well, I'm paying 02 taxes, that kind of thing, so I'm gonna keep
Keep
going,
sending them to the other district.
So it was tough, and they changed it, the 4 years I went, they changed it twice, the district boundaries. They kept shipping kids to Batavia or 131.
So here's the lesson, right, for us as residential real estate agents. This stuff really matters, and it's a moving target, so we better not be lazy about whatever it is that we're doing. Anything else anybody wants to add to that one? Number 5, we may be answering, what should have been done differently? More importantly, what do you think you would have done differently? But let's talk it out loud anyway. What specifically should Ms. Claremont, or would you have done, or would you want to do now as a listing agent to avoid this kind of problem?
State of school district. On paper, maybe just state it face to face.
School districts do have maps, and a lot of times they're online. Maybe you again, look at the tax bill, we talked about that. Maybe you send somebody an email with the district and just confirm. It's a lot of extra work if you do a couple dozen or 50 listings a year to verify everyone, wait for responses. What do you do if you don't get a response? And as we were talking, also, it may not be even a district boundary, but a boundary within the district of which school, North High School, Central High School, Matea, Nequifort, Waubonsie, which one. For some people that matters a lot. Anything else that should have been done differently here? All right. Number 6, do you think that the defendant agent or broker intended to commit fraud? Why or why not?
Maybe some. Maybe we did know. Yes, we knew.
Could be, fraud by omission, right, just saying nothing and just relying on, well, maybe they won't notice. It's possible. Does anybody else have an opinion? What do you think?
I think it's just laziness.
Just laziness? I think that's most likely based upon what I tend to see. Lack of discipline, trying to get the listing input, get it done sooner. But I don't really know that for sure. It's kind of hard to know the sort of a lack of evidence pointing in a particular direction. It does beg the question for me, if I'm an arbitrator or if I'm sitting on a panel looking at this, I have to sit and think, how much trouble would it have been for you to pick up the phone yourself and call? How much trouble would it have been to check the website? Do you not do this at all for any of your listings? Isn't there a certain risk? Then I would have wanted to look at the office policy and procedures manual, which wouldn't have necessarily existed then, but would exist today. And I would want to know, does the office policy and procedures manual for the broker tell agents that you should independently verify the school district regardless of what your seller says, and here are the options you have for doing that. At least independently verify it in one other way. In appraisal, appraisers are taught you must independently verify all data that you use, all data from two sources. So you can go in the MLS and you can look at comparables and you can get that sales data, but that sales data should be confirmed by looking at the public record or doing something else. Whether all appraisers doing sales comparison approach appraisals on residential transactions, or they're trying to do a dozen of them a day to make a decent living, do that or not is another matter. But that's how they're taught. Verify everything you get. If something is not in the MLS and you get that sales information from the public record, confirm that public record information by going and talking to a neighbor, talking to the person who bought the house, whatever you have to do. That may seem like it's a lot of extra work, but I can tell you that my own house, that you've seen a lot of data on in this course, my own house, the information when I bought that house in August of 2002 is misrecorded. It's wrong. It's off by over $50,000. It says I paid $292 for the house. I paid $340 something. I can't even remember what I paid for it anymore. But the way in which the data was taken from the closing statement and the way in which it was recorded is just incorrect. And so that happens. Stuff gets misrecorded. It doesn't make any difference in that case, but sometimes getting data from one source, even if it's reliable, may not be enough. So this case serves as a wake-up call to us to go, if that one and only source is wrong, what kind of risk are we taking? Remember, you're a professional once you're at this stage. It's not just the reasonable person care anymore, it's a professional level of care, and it's a higher level of duty. Just like as a high school counselor, for example, for Ebony. She's going to be held to a different standard of care when talking to a student about a certain subject than I would be if I'm walking out on the street running into the same student, because I'm not a professional in that area, right? So it makes a difference. Number 7, what are the statutes under which the plaintiffs are suing? First paragraph. One of them is one we really don't cover much in these courses, but apparently it really matters. And the other is one we've covered ad nauseum. So what are the two statutes involved here?
Consumer fraud and deceptive business practices, Act 815.
Yep, and so that's new for us. I mean, it's in the text, the previous text in the Road Set 100 course, but there's no questions in my database. We don't really talk about it. But here it is being, trotted out in all its glory. So here you have this sort of odd bit of legislation that probably isn't something you're ever going to see another question on for the rest of your career. But it's there. And what lawyers do, what plaintiffs' attorneys do when they file suit, is they find every basis on which to file the claim and support it. So you've got one case, one issue, but it's being tried under multiple statutes, so that if it fails in one area, it still has a chance to succeed in another. It's just like a fair housing claim where maybe HUD won't take the case, or maybe the fair housing statute hasn't been violated, but Civil Rights Act of 1866 has been. So you make multiple claims for the same count, for the same issue, hoping that something sticks. And the other statute, which we know is a big deal, is the License Act, right? I mean, that's, so being sued under the License Act and being sued under Illinois' Consumer Fraud and Deceptive Business Practices Act. And basically, for fraud and negligent misrepresentation, and it can't be both, it's gonna be one or the other. Right, negligent misrepresentation is that violation of the duty of care where you knew or should have known, or where you should have known, rather, where the standard of care says that the average agent would know. Fraud is where you absolutely knew and just lied about it, or said nothing, kept it to yourself. So those are two different things, fraud and negligent misrepresentation, but they affect the buyer the same way. So again, they sue for both, figuring if they lose on one, they'll win on the other. That's the general idea. Question number 8, if this were you as the defendant agent, what course of action would you take? So put yourself in Ms. Claremont's shoes after this ruling, which all that has happened is a hearing so far to determine whether or not there's even a basis for a lawsuit. That's all that we have here. We don't know anything more than that. And there is nothing more on this case that I've ever seen than this. I cannot tell you what the disposition of this case is. No idea. But at least the plaintiffs won the right to go to trial. So if you were the defendant, what would you do? Would you offer to settle? Would you want to see the E&O carrier offer to settle if that was a possibility? Would you go to trial, try and clear your name? Or would you want your broker to go to trial on your behalf to clear your name? Would you say, screw this, I'm going to go do something easier than real estate? What do you think? What would you do here?
Doesn't that school board have some degree of,
Culpability?
within there by letting those kids go there and, telling the family that, the house was within their district?
So the possibility, if you go to trial, you wouldn't bring them in a hearing, but if you go to trial, the possibility is to bring the school district in as a co-defendant, a countersuit, and maybe at least they'll contribute some money to a settlement, or to just put the blame off on them, which is I think what they were doing here, right? To say, hey, you called the district, they gave you the same information, we can't be held to a higher standard than that. That's basically in some way what the defendants are saying. I don't know whether the district themselves have any culpability. Courts are reluctant to when it's not super clear, like, police officers abusing the public trust and somebody's guilty of torture or something like we've seen in some of the Chicago cases. Unless you have some obvious abuse of power by the government, courts are reluctant to penalize, especially things like local school boards or whatever. Because if they do much of that, then the courts are in the business of running the schools, and that's not their role. So I don't know how a court would look at bringing them in. If it were private litigation, where it wasn't a public body, I think you probably do bring that other private entity in and say, we need another set of pockets to help us cover the potential damages and contribute to a settlement. Certainly, it does beg the question, what responsibility does the school district have? My guess is a court would just say, innocent mistake, and that they're not going to punish the school district at all, which leaves the private parties to sort it out, and this is my guess. What else? Who would want to take this to trial? Who would want to go to trial and prove absolutely, within the preponderance of the evidence, you don't have to prove a reasonable doubt, it's a civil trial, show that the preponderance of the evidence is in your favor that you did not commit fraud or negligent misrepresentation?
I think I would, first of all, do some research and see if they changed the district,
Okay.
recently, since even the person at the school knew, or seemed to think that that was that. And then if I had called earlier and checked on it, or someone had, because they talked about an acclaimed District 204, so to me, that seems like some pretty sure knowledge that it was in the right district. So I guess it would depend. It would depend if you had any evidence, but most likely I probably wouldn't do it. It costs more to.
Well, that's the problem with litigation, is that it's expensive, right? One of the advantages of having errors of omissions insurance, even though they wouldn't cover fraud, because insurance does not cover intentional acts. That's why you can't kill somebody for the life insurance money. Same kind of thing here. You can't commit fraud and then have your insurance company step in. But because it might not be a case of fraud, and it might be something that the insurance would cover, you might at least get insurance coverage, defense coverage. So the E&O carrier might pay to hire the attorneys to defend the brokerage firm and the defendant agent. And if that's the case, then that insurance company might be willing to contribute to a settlement. So if an insurance company like professional liability says, well, it's going to cost us $30,000 to defend the case, they might look at it and go, we don't really care. We'll pay these buyers 30 grand to go away, or we'll pay to defend ourselves and we think we're going to win. It's the same $30,000 to them. No emotion, not their reputation. It's all dollars and cents. So you might get that kind of contribution to a settlement. So there is something to be said for settling. Now, what's the risk of settling? If you settle a case like this and your insurance company coughs up 30 grand, what happens?
Rates go up.
Probably there's a rate going to go up. At least, even if that doesn't happen, that's your one freebie or something. So there's definitely going to be some kind of an experience factor issue here. And if you try and sort of go out and shop the policy, you're now going to have to disclose that we had this claim. So there is a risk to settling in that it's effectively realtors' malpractice insurance, what E&O is for us. And although you can do that, it's not necessarily free. So again, there's not a right or wrong answer there. Just something for you to think about and understand that this is the nature of being in business, right? It's not a job, it's a business opportunity. So you're going to jump into this industry, you have to realize that your actions could lead you here, which is probably not on the top of your list as you're getting out of this coursework going, woo, I can't wait till I have my first lawsuit. Then I'll know I've really made it big. Fortunately, I have never been sued for a residential real estate deal, but I have been sued for a lot of other things. Being a commercial property manager is kind of a trip, because if somebody gets injured on your property, they sue your ass along with everybody else that's on the list of anything. So commercial property manager, they don't kind of know what your responsibility is, so they sue you personally as they're suing the building and all the partners individually, and they just sue everybody. So then you're like, oh, this is wonderful, I guess. How do you deal with that? That's just part of the nature. Question number 9, based upon your reading of this case and the sections of the statutes contained herein, as well as information contained in Chapter 4 of the text, meaning from Real Estate 100, would it have made any difference if the agent or broker had relied upon information supplied by the seller? So we've talked about, the agent calling the district and looking at district maps and checking the tax records themselves. What if at the listing appointment the seller had simply said, our house is located in School District 204. Don't know where it comes from, don't ask. Would that have made any difference? I have a no. Only one no. Any yeses? Steve?
Yeah, I think that you have to rely on information your seller has, having lived there for a certain length of time. And
They didn't have their kids, though.
Maybe sent their kids, or no, these people didn't, but if they absolutely knew they lived in 204 and there was no doubt, you gotta pass that information on to your client, don't you?
I feel like you said, we're held to a higher standard, though. We're not just kind of people on the street, we're professionals. Do your due diligence.
Well,
even if somebody does tell you.
But the intent of this question, I guess, to distill it down, just to make sure that it's clear what I'm asking, can you rely on your client's statements?
Yeah.
I mean, Steve's saying yes, right? Now Caleb's saying yes. You're saying no.
Well, doesn't this kind of go to what we talked about last week, where we said the buyer said they had this work done, and by a contractor, it's kind of like we're relying on their word for other things. So I'm kind of in the middle. I see.
Well, they got proof for that contractor work, though.
For that, but then for the
Receipts,
other
all that.
2 items that were kind of, these things are, that one, yes, but there was 2 other items I can't think in particular.
Yeah, the whole.
But, I think to some respect, they've lived there, so I think it's a piece of evidence. I don't say it's, hold 100% truth to it, but if you have to get 2 pieces of knowledge on something, I would think the buyer would have some knowledge of where they lived for X number of years.
The seller.
Are they showing proof?
Yes, the seller.
But But unless
Do they have
there's a boundary
paperwork?
change,
Well-
which I would just say on the street.
Yeah.
They
You
have-
said there was, like, you're just like taking our word for it, we don't have proof we're in 204.
Well, that's what I'm saying, let's just assume in the
So if
case
there's no
that she
proof,
didn't
then
ask.
how can you take their word for it? You know?
See, I think technically, legally, this goes back to like our discussion that we had, the case that Ebony's citing, that Leaks case, where theoretically, we should have been able to rely on the seller's statements if we deemed them to be reasonable, that the seller shouldn't have had to worry about, 2.5 years. It should have been a reasonable belief that they had fixed things. Only we know now by experience, after having heard the whole story, that that would have been a dangerous thing to do. So in theory, you have the right to rely on the statements of your client. However, I would argue, and I have done a little bit of expert witness work in real estate cases, if it's easy to verify that information, on what basis do you then take the position, I didn't want to be bothered? Right? It's one of those kind of hindsight things. If it would be a lot of work, and if it's common knowledge that the public source you used is never wrong, for example, then, and everybody relies on it, then maybe you're okay. But if it's the kind of thing where that's not the case, which is sort of what we have here, because apparently the district didn't even know its own boundaries, and according to the verbiage at least given to us in the summary at the beginning of this case study, there's a lot of confusion about where the boundaries really were, which is kind of a duh thing for us now. Clearly there is, because we got this case. Then maybe we shouldn't be relying on this stuff, and maybe we should be verifying it, particularly if it's as easy as looking at a tax bill or something. And maybe the tax bill is wrong, for whatever reason, a boundary shift, things are just messed up so badly between government agencies that nobody really knows where it is. But now you're in court and you don't have one source, you've got two sources, and surely the court's gonna look at that and go, what a mess, case dismissed. Right? That's what you would like here. You're never gonna avoid every situation where somebody might come after you because they're unhappy and they're looking for a scapegoat, and you're a professional and you have insurance and they're gonna go after you. But you need to be able to defend yourself, or hand that off to the insurance company and let them defend you, and hope that it's a simple matter of getting the case dismissed without dropping the 30 grand, but just, a couple of attorney appearances and pre-conference discussion, and the case gets dropped. So theoretically, you can rely on them, but there's a kind of a classic sort of question that shows up in some of this pre-licensed practice. If your client tells you they have a half-acre lot, can you rely on it? Technically, the answer is yes, but if all you got to do is go online and check the county mapping department record for that property, or check the online property card from the township assessor to see that it's not a half-acre lot, I think that's a pretty weak thing to hang your hat on. So it's one of those best practices thing would be to trust but verify. Go ahead.
As far as the suing goes, can they go after you personally too?
Oh, yes.
Over and above your,
Oh, yeah.
right, so,
Yeah. Whether, that's one of the natures of you being an individual agent. Right now, if the brokerage firm itself is a corporation or an LLC, then the sponsoring broker is only going to be affected to the extent of the damage to their business that they own. But you as an individual, you're an individual. And there is no corporate veil or corporate shield there. That's one of the reasons why I don't bother to carry E&O, because I'm already a sole proprietor and I think I'm at risk for anything I do anyway. And I don't do a whole lot.
okay, so can you,
so.
can you create your own corporation?
Yeah, which is a way for you to then have the commission deposited, but your license is still an individual license.
So they can still sue you?
I think so. I've not been down the road in that regard. And keep in mind, if the state gets involved and there's a disciplinary action, those are personal fines, right? I mean, that you are fined personally by the state, and those civil penalties or criminal penalties or even criminal charges that can result are all against you personally. They're rare. The people that those are meant for are the people who commit fraud and who do it openly and who know what they're doing but do it anyway. For the average agent, it's not something you have to worry about. This is the kind of thing you have to worry about, where you look at it, and I think at the end, you can look at this and go, what the heck? I still don't even know where we're at on this.
So, is it necessary, so if you take a listing, to make and keep notes on the verification process?
So the question is, you know, sort of what kind of paperwork trail should you keep for real estate? What I hear in residential offices is brokers will tell their agents to put a note in the file. So it's not like you might have in commerce or in a commercial business-to-business kind of dealing, where you've got faxes and emails and a lot of specific things that you're going to have where you can go walk in with a file like this. Instead, you're going to walk in with a much smaller file, and it's not going to be what the seller told you, but it's going to be your notes about what the seller told you. Courts tend to accept that kind of thing so long as it was written at the time that it happened. If you write the note 3 months later, that's a recall issue. And that's a fairly common practice throughout industry. So people who bill by the hour, such as doctors, lawyers, are told to write down their time every day at the end of the day at the latest. Even on a Friday, to try and remember how you spent your 8 or 10 or 12 hours billing clients on Monday, less likely to hold up. So in this kind of thing, I think it's true also. If you have a meeting, you know, with the seller and the school district thing comes up, if you think that needs to be recorded, write it down, date it, put it in the file. That's the minimum. Personally, I prefer to do everything by email. If I have any question at all, I want it by email. That's a written record. Again, I come from private industry. I didn't just, you know, sort of come out of school and go straight into residential real estate. Construction industry is very litigious. I've done much more expert witness kind of stuff and litigation, arbitrations, mediations in construction-related cases than I have to date in real estate. And I've done it, you know, Texas, Florida, here. So I want a real paper trail, you know. That's how I think. But most residential brokerage firms probably won't hold you to that high a standard, but think about it. I think the problem here is I'm not sure she knew this was coming, right? I mean, and then so many years later, I think she's got to be blindsided by that. Even if she knew at the time, this coming up so much later, it's beyond the normal statute of limitations here. But with the charge of fraud, the statute of limitations is kind of taken away. I think maybe they could have gone 5 years. So maybe it's not. But anyway, it's a long time to wait to have file. And part of their claim is going to be we didn't know right away. There's both a statute of limitations and a statute of repose. So if the statute of limitation is 5 years, they're within that. If the statute of limitations is just a year or two on this kind of thing, then within that, say, 2-year time frame, for example, they needed to discover the error. And then they would have had whatever the statute of repose period is to actually file the lawsuit. So here it's fairly long. It took them at least 3 or so years to find out, because it was when the school district basically said you can't go to school there anymore. And I'm not sure they're litigating over that, or if they're litigating over, hey, now we want to sell and we're not going to get the same price we thought. We purchased the property based upon District 204. We're selling the property based upon Bolingbrook, and that's going to cost us 10, 15, 20, 30 grand, whatever the price spread is. Because now when they go to sell it, they have to market it for where they know that it is. Anyway, it would be best if you had multiple sources, and I think it would be best if the information had come from the seller. I think that would help the agent. Question number 10, keeping in mind that no trial court decision has been rendered, how do you feel about the agent or broker's predicament? I mean, if this was you, it kind of goes back to what would you do, but I mean, if this was you, how would you feel about that situation you're in? Would you think it was your fault that you were in that situation, or you would think it was just one of life's really unfair moments?
I'd feel responsible.
Would you?
I would, because I think that is something that really needs to be examined closely. It's because I witnessed it on my own street. And there was some unclarity on my own street.
Yeah.
Of what school the kids went to, and, you know, maybe if you
So-
lived in the house at this time, but
Right.
if you sold it and someone else moved in, well, then it was gonna change.
So you've seen this firsthand.
I have, and I really believe there needs to be some clarity and some documentation from the school district.
It's kind of interesting that, you know, because the buyers got the information from the school district, there's nothing in writing and there's nobody demanding that. But if that information had come, if the agent had said, we got the information from the school district, guess what the buyer's attorneys would have been looking for? Proof. Show us that that came from them in writing, right? And they would have to say, well, I just made a phone call. Who'd you talk to? Well, I don't remember. That would be back to, you don't even have a name in the file. You just assume that it's correct. Sometimes being in business is just kind of raw, and this is one of those cases, I think.
I read something interesting online today about how New York deals with that. Now it's considered steering, you can't even mention the school district.
Interesting. Very interesting. So it's legislated that way, apparently, state law in New York. City or in the whole state?
I believe it's like, you know, I don't know for sure, but I know it's in the city of New York. It's steering, you can't even mention it.
Which it would be if it's just New York City Council passed, an amendment to their Human Rights Act or whatever they call it there. Anything could be steering if you put it in there, and you're not supposed to violate it. Because it's a huge issue. Definitely drives value. And in urban markets, you're watching that sort of bleeding edge of where people want to be, and then all of a sudden the neighborhood goes from being cool to being blighted 10 years later because nobody wants to live there. Maybe because of a school boundary change, or the perception of a school, or the principal abuses a kid, and then everybody in the whole school is painted with that brush for 10 years. Who knows? It's just hard to imagine what things might drive those kinds of things. It's very interesting. Any other thoughts or comments or questions about this particular case? Again, just to summarize, I have no idea what the outcome was. No idea. This particular office is RE/MAX of Naperville. This is a big office. They have, I think, still 2 locations. Last time I did business with them was quite a few years ago, maybe in about, 2007 or 2008 or something like that. And they have about 90 agents in each of their offices. And those are all desk fee type, been in the business a long time kind of agents. So I had a student in here who she was an unlicensed assistant at the time she took the course for this northern office. And she didn't know this gal, but she worked in that office. It's kind of interesting to go through the case study with her. I mean, it just, sometimes bad things happen to good people. So be careful. Exercise discipline. Try not to be in too big a hurry. The biggest thing to take out of this is the fact that a little bit more checking, a little bit more due diligence would have solved the problem. The challenge with it is you wouldn't have just done it on this case. You would have done it on every one of the 2 or 3 dozen listings you do that year, or however many it is, and that adds into hours to your time. So you have to be a little bit careful how you spend your time in business. You have to be a little bit careful how you choose to spend your time as a real estate agent. Because if you waste it chasing people who are never going to close, if you waste it working with people who seem like they're real customers but they're not, because you don't screen them well enough, because you don't say no if they won't sign your buyer agency agreement, because of whatever reason, then you spend time doing things that don't lead to business, and then you can't do the best job you could do on the deals that are absolutely real deals. So at risk of getting a little bit close to the antitrust line, just be very careful how you spend your time, because you'll do a better job for your clients if you're making more money because you're more efficient with your time and because you charge enough money that you can do the best job. Those are lessons from my world, not just in real estate, but in every business I've ever been in. Making a business more efficient makes it better. It makes it better for the clients. Even if they pay a little more, they get a much better deal out of it in the long run. All right, so we're good with that? Awesome. Then let's go on to our big, exciting book. For those of you who don't have it, this first one is basically going to be a numbers thing here. This is the listing presentation and the seller's net sheet that goes with it, and when we take a break in a little bit, I'll see about making you copies so you can look at it at that point in time. Bless you. And again, for those of you who don't have it, you can see me on Thursday or whatever and actually take a look on break or before or after class and look at what the answers look like to make sure you got all this information down. All right, so we've got some questions here. We've got basically this listing presentation, so I'll summarize it. We've got a seller who's got a brick and frame, 1,500 square foot ranch style home in Sunnyvale. He's talked to a bunch of real estate brokers, 3. Previous list prices of his house, he's tried to sell it for a while, $315,000, 180 days on the market. $300,000, 90 days on the market. $250,000, 90 days on the market. There are 6 listings for ranch homes right now between 175 and 235, way less than where he was. There's nothing in Sunnydale as high as 315. There's 5 2,000 square foot 2-story dwellings listed for 285 to 299, so they're much larger and higher priced. The highest ranch sale in the last 6 months, 215 with 4 months in the market. The real estate broker shows up for a listing appointment. She's got her camera, her smartphone, whatever else she needs. Seller goes, I need 200 grand at a minimum after I pay your commission. And I hope you're not as pushy as the last agents who came through here. Told me I didn't have a hope of selling it. Gal makes some quick calculations, looks at the CMA that she's prepared, and she responds, quote, in order for you to pay our commission of 5% and for you to receive 200 grand, we'd have to sell your house for 210,500. That would have been a good math problem. Wish they didn't give you that. That's straight out of the prior class. But that doesn't cover your other closing costs. We should add 5 grand for good measure, make it 215.5. This will be tough. It's the highest sale of a ranch is 215. I've been inside that ranch and it was in better condition than yours. These are the conversations you get to have with your sellers. Hey, thanks for inviting me over. Your house is just ugly as sin, man. Seriously, you've been living here for 30 years, you still got the same carpet? You have to find tactful and diplomatic ways to talk to people. Well, but, this is what happened, because people will sometimes believe they have the best house in the best condition in the
Yeah,
neighborhood.
there's a tactful way of making.
Right, but that's correct, and that's what I'm saying.
Outright.
Yep. Well,
And
you
that's
have to be
frustrating.
tactful, but you also have to be frank and
Yeah.
figure out the balance for that, because of course, what are you trying to do here? Get the listing if it's at a price where you think you can sell it and make a decent amount of money for the time involved. I've been inside that ranch was in better condition than your home. Can you be flexible about your asking price and sales price? All right, so that's the basic idea. So question number 1, should Anita, who's the listing agent, accept the listing at any price and hope that John, the seller, is reasonable later and lowers his asking price? What do you think? No, and
No, he's already gone through other agents. She's not the first one. He wasn't reasonable with him. Why would he be reasonable with her?
so this guy's just a jerk. And you're
Yeah,
gonna,
that's how I see him, yeah.
so you're
I
gonna
feel like
just,
he'd be wasting my time, to be honest,
well, no, that's a
I'll
good,
spend
that's a
3
good
months,
question.
6 months trying to sell his house, and he's not gonna be flexible. I just wasted, a quarter of my year on this guy.
And that's correct. And then what happens is everybody in the neighborhood knows you can't
Can't sell the house.
sell the house.
Yeah.
And or can't, give a decent professional opinion worth listening to, or whatever it might be. That's one of the risks of taking overpriced listings. On the other hand, once you have a listing in hand, it's much more likely you're gonna be able to get somebody to reduce their price than if you don't have the listing in hand, and they decide finally when Maria comes along, or Christina comes along, and they convince them to sell for, 5 or 10 grand or 15 grand less, and they end up with it and get a quick sale. So that's the challenge, right? So the question here is, do you take the listing knowing that it's a little bit or somewhat overpriced with the hope that you'll get it reduced later on? Okay? Tom just thinks the guy's a jerk and
He mentions he's had other.
No, that's
people trying
true.
to sell it.
There's a reason why they make this case the way it is.
He didn't
This
push
is a
for
very
me.
real kind of thing. You
Well,
run into
he
people.
pushed for me.
Yeah, you run into people like this. What do the rest of you think? So how overpriced would you be willing to take a listing, do you think? That's a great definitive answer, just a little bit. Steve?
I kind of put down, I tried at the 215 mark since a house did sell for 215 in that same subdivision. And be honest with the seller and, maybe try it for 2 or 3 months at that price, hoping for a buyer, and then have that conversation about lowering it later.
So if you ask 215.5, let's say, whatever the number is that they needed to get, what's the likelihood at any condition, not, specifically today or any given time, but on the average market, just thinking about how sales go of any kind on big ticket items, what's the likelihood you're gonna sell at 100% of the asking price? 0. The odds typically are that's not gonna happen, right? Because the assumption is the buyer's gonna offer something less. Unless you're in certain markets right now, I think like downtown core Geneva, things are kind of skyrocketing a bit. There's some places that are really coming back with a quick, fast pop. and you're in that kind of scenario, you'll get multiple offers, in which case now as a buyer's agent, right, you have to be advising your buyer to jump. Go ahead.
Would it have anything to do with the time of year as well?
Oh, it could have a lot of, right, because
Because
you get jumps, right?
Right.
People want to move between, you know, the June and July, or June and August period. If they're gonna change schools, they want to do it, you know, during summer. Investors, if they're gonna buy a property to put on the market, they'd rather have their rentals turnover in the summer if possible. So yeah, I mean, it can. There certainly are a lot more transactions in the better weather, partly because the winter has the holidays where people are too busy visiting. It's as much that as it is weather. And you tend to see, prices don't go up in a linear way. I tend to think they don't, you know, they get into a season and they stay, and then all of a sudden for the next season you'll see them jump up or something like that. But market's been very erratic the last 8 years. Bumps up and down, so it's a little bit harder for me to get a handle on some of these things today. What do the rest of you think? You gonna take the listing? If you are, at what price would you be willing, you know, would you, like Steve, are you gonna take it at that 215.5, or are you gonna say, I'll take it, but only if you'll list it at whatever? And what if the guy says, well, 215.5 is okay, but, you know, we gotta have some negotiating room? Well, let's ask 220. Because 2 to 3% negotiating room is very common. That gives everybody kind of their expectation. You think the thing's gonna sell for 215, which you don't here, but if you did think it was gonna sell for 215, you'd ask 220 to 225 at the highest, maybe 222, somewhere in there, so that you have negotiating room. Or a buyer who comes along and says, I'll pay your price, but I need you to give me back 3% in closing costs, attorney's fees, whatever else, that kind of thing. You gotta have that built in, or you don't have room to do it. Because by FHA rule, for example, you can't raise the asking price to cover loan closing costs, et cetera.
Well, it sounds like at least he was reasonable enough to be talking to doing some upgrades so that it could sell for a higher
Possibly.
price. Well, they said on the next question,
Yeah,
there's $5,000 for remodeling. I'm assuming that's the same house. Just thinking.
in this one, or are you talking about the next house?
The next question, you know, but the next.
Oh,
question,
yeah, under
we
the
do
seller,
that, I
under
think
the
it's
seller's
same
net sheet,
people,
yeah, under the seller, yeah, right, I got your, here it is.
So,
Yeah,
yeah, I'd take it, at least at first, I don't know, maybe after we've sold a few, we maybe change our minds, but at the beginning, you know.
well, that's the challenge
You
a
gotta
lot
see
of
how it
times, is
goes.
at the very beginning, when you get into the business, all you wanna do is get something going, you know, and so it's easier to sort of end up with these overpriced listings at the beginning. You're optimistic, you haven't figured out yet that being busy isn't the same as making money, and it's hard to tell the difference between the two until you've been through the experience a number of times. So I'm not gonna tell you what you should or shouldn't do in a case like this, except to advise you to be aware of what the potential risks are either way. Certainly if you know, walk in and, you know, turn down listings, then that's gonna get around too, that don't invite so-and-so because they're just gonna tell you you're crazy and not take your listing anyway. Go ahead, George.
But you know, I was just gonna say that my sister is like this professional, her and her husband, like, they buy and sell more than most people change their shoes, really, and it's like constant. And they always start out higher, and they start out with one agent, and then they go to somebody else, drop their price, and then she just raves about that second agent, about how great they were. I mean, I don't even think it hits her that, well, you're selling it at a cheaper price.
Right.
You know, so that kind of gives you a different kind of a, you know what I mean? It's
Yeah.
like your name's gotta get out there.
Right,
So,
you're-
I don't know, so there's, yeah, pros and cons, I'm not sure what to do.
You do need to know, this is a bit of advice, you need to know where the market's headed. You need to know if it's headed up or if it's headed down. And that's not always easy to know, particularly at the change of a season, where maybe you haven't had a comp for 4 or 5, 6 months. Or last year you had 15 houses on the market, and this year in the same subdivision you have 3. What difference is that gonna make? Any? I don't know. How fast were they absorbed last year? How many more buyers are out this year? You might not know yet. So you take a risk when you take that listing, kind of trying to predict the immediate short-term future. I do think it's important at your listing presentation to have a conversation with your seller client, the person you want to have them become your client. If we don't get any activity at all, that's a sign that nobody's interested at this price. If we're getting showings but no offers, that's a sign that we're close, but not quite where we need to be. How many buyers do you need in the market for a house to sell? Just one. But, you know, that's the one buyer you need at that price. So in theory, as a listing agent, what you're trying to do is figure out within the time frame that's acceptable to your seller, where do you need to be in terms of price and condition so that that one buyer is found and bites at the highest possible dollar amount. It's categorically impossible to know you're doing that on every deal. But that's the basic idea, right? Based upon all these duties we've looked at, that's kind of what you're shooting for. Now, the risk is if you shoot too high, the buyer comes in, sees the house, it's overpriced, so they don't like it, and they never come back. Now you don't need one buyer anymore. Now you're trying to find the second buyer, and you don't even know it. And they may or may not be at that price. They may be $5,000 less or whatever, you know. It's hard to know. So you need to have conversation with the seller. Informed seller is a powerful ally for you. Even if it's a matter of going back to them 2-3 weeks later, saying, you know, we haven't had a showing in the first 3 weeks. We have got to be way over the market. Or the agents who all came through on the agent tour or from our broker open for our office all said, for the condition, house is overpriced. And you don't have to deliver that news. You can put out written sheets asking agents to give you their opinion of what they think the price, the value is. I see this a lot. Not many brokers go on broker opens or agent tours that are put in the MLS where you tell your seller, brokers are going to come through here Tuesday between 10 and 2 or whatever the deal is in your area, whatever sort of customary. Or if you're like me and you don't have anybody else in your office, you don't have an agent tour from your office. But if you work for a big office that's got 30, 40, 50, 80 agents, you might get a dozen come through just from your own office. Put sheets out, sit there if you must, and ask them, please fill this out. Then when you sit down with your client, and one of the questions on there is, how do you feel about the price, knowing it's just been listed for a week, you've got some other feedback. And you say, well, this is the opinions I got from the other agents who've seen it. Go ahead, Steve.
We got a duplex for sale. My real estate agent told me the other day that the buyer's agent said that it was a good showing. What does that mean?
That's a good question. Good showing means that they like the property. If they, I would think that it would mean they think it's fairly priced. It's kind of nebulous. So I mean, that's really a question to ask them, what that means exactly. When homes are shown, it's important that the listing agent solicit feedback from the buyer's agent. You'll get anything from buyer's agents who say, that would violate my fiduciary duty to my buyer, which in theory should mean they like the place and they don't want to tip their hand, to that's just their policy and they never give feedback to anybody on anything, to agents that are very helpful. Unfortunately, some of that helpful feedback is it's way overpriced, we didn't like it, you know, whatever. But at least there's some detail there. I will occasionally look at a home that I know my buyer clients aren't interested in, but I think is a good buy for somebody, and I'll give that honest, straightforward, seems to be fairly priced. Knowing that if nobody else gives, makes an offer in a month or two, they're going to drop the price anyway. But also other times I'll, tell an agent, I think you're way over the market. And they get to decide what to do with that information. Now the question is, do I tell that to a listing agent where I think my client is interested, but they would be interested at 10 grand less or 20 grand less? Do I make that point that, yeah, my client's interested, but they think the house is worth, 20 grand less? Maybe. What you oftentimes get there is an email back that says, make us an offer. Which means nothing other than make us an offer. So to answer your question about what does it mean to have a good showing, I would assume that it means that they like it and they might even be interested, but that should be part of the feedback you solicit. So in our local MLS, you can set up different kinds of feedback questions that you ask. So you could have just a general tell us about the showing kind of thing, or you could specifically say things like, what do you think the price is? What do you think about the condition? Does your client have any interest? How does it compare to other houses you're looking at? And then that can be a series of drop-down boxes that all the buyer's agent has to do is just click and they're done in 3 minutes, 2 minutes. But at least it gives you something. Otherwise, you can call them. But again, keep in mind that some buyer's agents will never return your call for feedback. They just won't take the time. It's 'cause, right? because there you are sitting there,
I
you'd
just
like,
figured
you'd like to know.
there was no negative comments while they were looking through the house, and that might be a good thing.
Yeah, it could be, right, that wouldn't bother me. If I was a seller and somebody said, hey, it was a good showing, I would say, awesome. But then I would wonder, like you are, what the heck does it mean exactly? Yeah, yeah. All right, anything else about that first question? Keep in mind that it takes a written, amendment from the seller, to drop a price. So you really, you can have an oral agreement to revisit the price later, but that oral agreement is worthless, right? It's not enforceable, you can't force them. But some people it works well. I've certainly taken my share of overpriced listings and just worked our way down until we hit the market. And the sellers were happy with that. I one time had a seller, we were going from say, whatever, 303 to 299.9, and so I made the price adjustment, and she looked at it in the MLS and called me within an hour and said, no, I don't want to be at 299.9, I want to be at 299. Oh, sorry, misunderstood that. So when you get a seller who's really, we really got to sell the house, it's kind of a nice place to be because they're telling you, you got to drop the price a little bit more. You don't always get that, right? Because it's their money. Again, it depends. A seller who's trying to downsize, you can convince them possibly by pointing out how much money they're going to save after they move out, right? Because it's all about money in your pocket for the seller in some cases. So yes, maybe you'll lose a few $1,000s or $5,000 or $10,000 on this end, but if you sit on this for another year, how much is that going to cost you in interest and taxes and upkeep and things you don't want to be doing? Wouldn't you be better to just get out now, take what you perceive as a hit, but save the money on the other end? Come up with creative responses to be able to come up with answers that suit both you and your seller. Question number 2, can Anita say, everyone charges a 5% commission, it's the standard? Right, that's clearly an antitrust violation. At this stage, everybody should get that that's the kind of thing you can't say. Commissions are negotiable between the parties, so negotiate whatever. I had clients where I've charged them various, varying commissions depending upon what the deal was, to various choruses of, really, you can do it for that little? To, seriously, why are you charging me more now than you were charging me before? It kind of depends on the situation for me as to how much work do I think I'm going to put in, etc. So I have to be prepared to explain those differences. Question 3, what data should Anita have in her CMA? So think about comparative market analysis. What's going to be in there? Say it louder.
Recent sales?
Yeah, the comps, right? Recent sales. How many? Minimum of 3, but you could have a dozen if you've got that much information. Remember, keep in mind, you can show your client all the data that you want. Even if you just have a nice simple sheet that's got the 3, you could have a file with you that's got many more. And I would recommend that because if you're in a subdivision that sellers have been in for a long time, they may know more about what's happened in that neighborhood than you do. And they may say something like, well, what about the Johnson's house? Well, which house is the Johnson's house? Well, I don't know. It's, the one down there, blah, blah, blah. And then all of a sudden they're telling you, well, that house had a home theater in it. Did they sell it with the home theater? You may not know, but maybe it'll be on your detail. Maybe it'll be in the listing. So, those kinds of questions sometimes come up, and if you don't have anything else with you to look at, you might not be able to answer their question. You still might not be able to answer it, but at least now you can make a note to say, I'm not 100% sure about that. If you have a tablet, laptop, wireless device with you, you may be able to look public record, you may be able to look in the MLS. So have that capacity because these things sometimes come up where sellers will ask you questions, you need to be able to answer them. What else goes into the CMA than just the comparables?
Square footage, bedroom.
Yeah, what are you going to adjust off of? Whatever the issues are on that particular property. So this is going to vary by the property. If it's a unique property, you're going to have different adjustment points than if it's cookie cutter. This is just one of 4 model XYZ that have sold in the last 6 months in that particular subdivision. If it's the Applewood model and everything on the market that you're looking at are all Applewood models, you've got a lot of that data that's all going to be the same. If none of them are, you have to look at that. One subdivision that I looked at recently has about 6 different home styles in it, and you could look at it 1 year and none of the particular home style you're looking at sold that entire year. And then all of a sudden in another year looking at it and 5 of them sold. So, depending upon which year you get that listing request, you're going to have no data or you're going to have good data. So you just have to, figure all that stuff out. Yeah, and anything else that sort of relates to the details of the CMA, obviously, should be there. You should also have good marketing data. When we look at the MLS a little bit later in this course, I'll point out to there, you have the ability to create, custom sheets. So things like your face, your name, your cell number, all of your sort of marketing material should be part of the CMA. It's not part of the CMA itself, but you need to always be thinking about that, right? You're not only doing them a good service by providing them value, you're also there to sell yourself and make sure that they remember who you are. So don't forget that as sort of part of your overall strategy. Your face, your name, your cell phone number, your personal email address are all part of your branding. Yes, you have to give them your broker's name. Yes, that has to be in the materials. But you don't want to give them your broker's office phone number as often as you want to give them your personal cell number. You may leave that office someday. You need them to follow you, right? You need them to follow you to your email address. Many brokerage firms will give you, your own email address at theircompany.com. Awesome. But when you leave that firm in 5, 10, 25 years, you can't take that email address with you. You can't forward those emails. They will truncate that the moment you're gone. Maybe even take those leads and you keep them for themselves. So you need to make sure that you have your own personal promotional stuff going on at the same time. Question number 4, Anita, the listing agent, says, the other agents aren't as good as I am. They've been sanctioned by our state licensing agency. Can she say this? Should she say this? I mean, it's about selling yourself, right? So why not? She probably could, but she shouldn't. Okay, why shouldn't she? If she can, why not?
Well, it's not that you sell yourself.
So how do you sell yourself? What's the way in which you should,
Be trustworthy,
okay,
build a trust, build camaraderie with them.
all right, but what if they ask, you know anything about these other agents, and you know they suck?
Drive them to the PFR website.
Yeah, you could say to them, yeah, it's public record whether somebody's been disciplined or not. That's up to you to check it. I think that's a reasonable thing. I don't think you do that only if you know that. That's become part of your standard response if somebody asks. Of course, you have to make sure you haven't been disciplined, because then the next question will be, have you ever been disciplined? No. Has your broker ever been disciplined? Well, I don't know. Because there are quite a few people working for brokers where the managing broker or the sponsor has been disciplined for something that was accidental, but it was still a disciplinary action. And once it's on your license, it's there forever that the discipline occurred. So I think the general idea is you sell yourself by selling yourself, not by selling against somebody. Right? You sell what you're going to do for them. But here's what I can tell you about us. We work diligently, to promote our properties. I'll be, available to you as quickly as I can at any moment in time by phone, by email, by text if you have problems, if you have questions. I'll deliver the offers to you as soon as it's practically, capable. Whatever things you want to highlight about yourself, sell your positives and ignore the other agent's negatives. Right? And I think that way it kind of comes down to what Georgie was hinting at about being trustworthy. Just, point out to them, look, I'm not here to bash anybody. I'm here to just tell you that I think I can do the best job. And I'll work hard to earn your trust. I'll work hard for your business.
Now, once it's been established, can you show them records, like here's the houses I've sold?
Oh, absolutely.
and everything
Yeah,
like that?
you bet.
Okay.
And until you have personally been established and have your own track record, whose track record are you going to rely on? Your broker's, yeah. So when you get questions, at the first listing appointment you've ever gone to, and they say, how long have you been doing this? My answer is, the brokerage firm I work for has been in business for however long. It's an answer. Or I could say something like, I've been involved in real estate here since, it's going to go back to when I bought my own house. That's legitimate experience. If you've bought and sold before, that's legitimate experience. If I'm dealing with somebody who's an investor, I'm going to say to them, I had my first residential rental property in year X. That doesn't answer how long I've been a broker, but it usually satisfies people. Very rarely do I have people kind of dig in deeper. How long have you been doing this? I'm thinking to myself, doing what? What could I answer? Breathing? I've been doing this for a long time. right? I mean, and usually they're like, okay. They don't know that I'm saying, yes, I was talking when I was 9 months old and I've been talking ever since. So you decide how to answer those questions. But you want to think about that kind of thing in advance. Can't lie, have to be honest, right? But you don't necessarily have to be that direct. You have to provide them with expertise, but you do not have to have any experience. There is nothing in the Act that requires you to have experience. It requires you to have expertise. You can get that from a mentor, from a broker, from your past experience, being licensed before, whatever.
You can take these classes?
I think, yeah, to some degree. As soon as you pass the state exam, you're an expert as far as the state's concerned because you're held to a higher standard. And just think about the case we just talked about. I think Ebony and Kate, because they both have lived this, were probably a little more strongly impassioned about that. I think their experience is as legitimate as if it happened to them as they had a license. Right? And I think you need to find out, Maria's been doing mortgages for a number of years. That's professional real estate experience. So if I'm Maria and somebody says, how long have you been doing this? And I'm at my first or second listing appointment, I would say, oh, I started out doing mortgages in this business, whatever. If it's long enough, you can just tell them exactly when, or you can say, I started out in mortgages a number of years ago. I mean, 1 is a number, 2 is a number. Then, see what I'm saying? It's different than saying, oh gosh, thanks for asking. This is my first appointment. I sure hope you list with me. You guys got to make that call how you want to handle it. People want somebody they can trust. This is not rocket science. Every bit of backup you need should be there with your broker. You should have figured that out before you hung your license there. That's part of why you interviewed them. Somebody else had a hand up?
Yeah,
George, go ahead.
I was just gonna say that we tell our students this when they go out and they start working on people's hair, or however you guys did that too with the skin, is that you don't ever wanna tell them they're the first, because you're opening up your vulnerability to them. So if they have any issues at all, wanting to sue, wanting to find problems.
You're giving them an
you are.
excuse,
You're
right?
giving them an excuse, right? So you don't ever wanna do that.
Again, the license law clearly demarcates the difference between experience and expertise. So be an expert, be worthy of the trust, spend the time, know that on the first few times you do this, you're gonna spend way more time dotting I's and crossing T's, if you will, trying to get it all right, than you will once you've done it 10 or 20 times, because you'll be able to do the same stuff. In fact, it will amaze you, once you've been in the business for a while, how much more quickly you're doing things than before. And hopefully at that point in time, you check yourself to make sure you're not omitting important steps because you've gotten lazy with your habits. But good habits, can help a lot. All right, let's see about doing one more here, and then we'll take our break. And then we'll come back and do the settlement sheet. Question number 5, John is frustrated in his inability to sell his house for the amount he wants. What should Anita, the listing agent, do to educate him? Will this education process help her obtain the listing? If so, how? You guys are so darn quiet.
I love how you responded with, look at what you're gonna spend if you stay another year. Look at your taxes. Look at your.
Of course, that only works if you've got a downsizing,
Downsize.
right? Right, but that's a script then for that person. And if they're going the other way, if they're looking for the house of their dreams, maybe you play on the emotions a little bit.
The house could be gone.
Where do you see yourself in a year, Mr. and Mrs. Seller? Do you see yourself here? Would you rather be here, unhappy that you're still in this house with the kids crammed in a room, with the baby having to still sleep in your room, whatever you can see? Or would you rather be a little tight on money on the other end, but be in the house you really want to be in? Have the kids be in the schools you really want them to be in, whatever it is. I mean, to some degree, you're kind of playing on their emotions, but isn't that part of life? And don't they have to make the money versus emotion decision? Again, you're just there to present them with all sides of the picture and let them decide. You're not trying to sort of con them, but you are trying to point out to them the reality of things. And sometimes it's tough to make a decision. So part of your job is going to be educators. You're to educate these clients and prospective clients.
My son and I were talking about this actually just last night. He bought a house 4 years ago from this gal from Naperville. She was an older gal, actually, and really nice. She treated him like she would her own son, and he felt very confident with her and all that. So trying to think about when she had him sign the buyer's agreement. And you know when she did it, and I thought this was kind of smart, but I wanted to get your opinion on this too, is that she showed him a couple houses, and once he got really excited to put an offer in, that's when she brought out the contract and said, this is what and he was so excited, he says, Mom, I don't remember. I don't remember signing it, I don't remember what she said, she could have charged me 10%, and I wouldn't have known. And, so I thought about that, so I don't know, what do you think about when you bring that kind of a thing up?
Well, keep in mind, the written designated agency disclosure has to happen almost immediately. You really shouldn't even show a property in theory. Here we're in a classroom, right, so I'm a college professor. It's kind of an academic statement, but it's a legal statement. If you're gonna show somebody property, you really need to make sure they understand you are their designated agent. Illinois requires it, so that part should happen right away. But as far as waiting to say get an exclusive buyer agency agreement or something like that signed, I think that's a business call. So if it seemed to work for her, why not? The risk is, of course, you end up showing some people some places and then they don't come back. But I don't know if you can avoid that. Just keep in mind, again, particularly to get through the test, that written designated agency disclosure is critical. It's already built into the listing agreement. But if you don't have a buyer agency agreement and that agency relationship starts as an implied agency, you're now in violation of the license law for that period of a couple of days, few showings, whatever.
So really, you
Agents,
need to do it sooner.
agents violate that all the time. Oh yeah, it happens all the time.
Well, because sometimes, you
Ignorance,
don't always want to,
laziness.
do people really want to sign with somebody and have them right up front until they?
Well, no, I think that's true, right? Anytime you're selling, you're looking for objections. And one of the objections is, I don't really know you. I don't really know that I really even want to do this. I'm just kind of kicking the tires. Can't you just be my free tour guide? Then, correct, putting that in front of them might be like throwing a little water on a fire when you're trying to get some steam, and instead you put it out.
Right.
So, other than just that disclosure thing, I don't see anything wrong with what she's doing. It's just a question that you have to decide in the future. When do I want to, try and get that exclusive buyer agency agreement?
We bought our house, I don't ever remember giving or signing anything with our buyer agent. Could he have gotten something to the MLS with the listing agent, and we got to deal with that?
As far as the co-op fee, that's exactly how it works. Co-op fees on residential properties are typically all right through the MLS. Like this multiple listing service here, by rule, this is not a law thing, this is not an issue for this course or for the state exam, but by MLS rule, you cannot put a listing in the MRED MLS database without a co-op fee. It can be next to nothing, but there has to be a co-op fee. So the whole purpose for the MLS is to create a contractual relationship between me as the listing agent and you as the buyer's agent. You know exactly what you're gonna get paid before you ever show the property. You can't refuse to show it because you don't like the fee, and you can't use the contract as a means to demand a higher fee, but you can look at it and know.
The house we ended up buying was one that we found, but he had a list of 5 or 6 that we looked at before.
Yeah.
Could he have gone on MLS and made sure that there was some kind of fee involved for him
Yes.
before he
Yep.
picked the ones he wanted to show us?
Could be. Yeah, I mean, one of the questions that I have, I never bring it up in this class, but it's in the online Real Estate 100 class for a couple of the people who came from that, is that, you've got clients who see 2 houses, they're absolutely identical, same price, same features. One's a 2.5% co-op fee, one's a 3.5% co-op fee. Which one do you want to sell your buyer? Right, well, the point is, A, it should be irrelevant, commission should be irrelevant. On the other hand, it's a fact. And buyers, I've had buyers say to me, ooh, we don't know which one we want, you tell us which one we should buy. And then you tell them, well, I really can't, and by the way, I'll make 1% more if you buy this one. I've had buyers say, oh, you'll get more money? Cool, we'll buy that one. You could also get a buyer who would look at it and go, oh, really, the fee's higher? Well, then these people should be willing to sell for less if they're paying less to sell the house. So either way, that compensation is grounds for disclosure, right? You're going to get a co-op fee, you need to be able to tell them what's going to your broker. But agents should not be making decisions based on co-op fees. It's irrelevant, right? Your duty is the same regardless of even whether you get paid at all, much like how much you're going to get paid. That having been said, in '98, I put some flyers out. I had this listing that was going to come up. I knew it was going to come up at $725,000 exactly. I had this called pocket listing, basically. 2 months from that point in time. So this was December or January, December maybe, I knew this listing was gonna pop. And, 1998, $725,000 was a lot of money. It's still a lot of money today, I guess, but not as much, in terms of housing. So, this was in DuPage County, so I found all of the real estate offices within a certain radius of there, and I made a flyer, single page flyer with my information on it, no other details, and it just said, how would you like to earn a $30,000 commission on one single sale? That was it. That's all it went on the flyer. Got the seller's permission. The seller had agreed, rather than drop the price, and rather than offer a 3% buyer co-op, we would leave the price at what they'd had with the previous agent before, and they would pop for a 4% co-op fee. So that was the opening advertising, marketing for the house, to let all the agents know, no address, no other details, nothing else, but that this house was coming. Just be prepared. And then when it got to be a month before, we did another flyer, and then finally we did the flyer with the house to show what it was. We didn't sell it at that co-op fee. They ended up having to drop their price below 700 somewhere, and they ended up with a 3% co-op fee. But still, it was 20 grand or a little bit more. And it was a way to use that co-op fee to get other agents' attention. But if another agent was deciding to show that house only because of the co-op fee and was not showing something else because it wasn't high enough, they would be violating their duty to their buyer. Loyalty, all of your interests, all of your self-interest have to be set aside. Everything runs to the buyer, not to your own self-interest. So that's where that co-op fee can become a problem. But practical reality of it is, a lot of agents believe it matters what the co-op fee is. And I can tell you, for myself, occasionally I'll look at a house and go, really? You're only paying that? And then I remind myself, okay, can't look at that. So it's one of those things that you know how it works in theory, and you got to explain it. So if you get a seller who doesn't want to pay as much in a fee, you can point out to them, well, one of the ways to pay less is to pay a buyer's agent less, but the risk of doing that is not as many people want to show your property, and you might miss that one buyer. Now, in theory, no agent should make that decision, but human psychology is a little different. Anything else on this one or any of the stuff related to it? I don't know the answer as to what will actually work or what won't work. Could be any number of things, there's not an exact science to this stuff here. Know your market, know if the prices are rising, know if the prices are falling, because that's going to have an impact. When prices were falling in 08, 09, 2010, many listing agents were having a heck of a time because their people had, looked at their house value 3 months ago, and then you're coming in and telling them it's worth even less. And now people are sitting there having to go through another adjustment while you're in their living room trying to convince them that you're right and their 3-month-old impression is wrong. That's a tough spot to be in, but that happens from time to time. Hopefully not as much as it was a few years ago. In an upward moving market, if you're a bit of an optimist, the market might cover you on that. All right, let's take a break. Let's come back at by 8:15, and I'll go try and make a couple of copies of 1 and 2 and 4. And just Caleb and Ebony, right, who don't have these? Right. Okay, and I'll be back by 8:15, hopefully.
This is the homework you wanted.
Oh, yeah. Is that a copy for me? Or-
Yeah, I'm looking for which one.
Oh, that's all right, as long as I got something. I'm gonna submit,
I'll give you all three of them.
I'm gonna submit you're good.
The video wasn't online yet.
Okay, well, when it is,
I'll
just
look
get a
at it.
gander at it. And this is class, as you can see, is a little bit different than the last one. It's not like you're missing lecture stuff, and none of this is new. But definitely watch it, and then just let me know once you have.
Okay.
I might have you write me up a short note or type me an email that refers to the content or something. Won't be much.